Good morning. I think we're ready to start. My name is Phil Prygoski. I teach constitutional law here at Cooley. I've been doing that for about 34 years now. And on behalf of Cooley Law School and the Cooley Law Review and President LeDuc, I would like to welcome you to our Law Review Symposium for this year. Really want to thank you for coming. What's going to happen is I'm going to give some introductory remarks. Then I'll introduce the speakers, and each of them will speak in turn. And we'll have a question and answer period after the speakers are all done. And there will be microphones set up in the room, and we'll take the questions and deal with it that way. Now, there's one modification to the schedule. Jim Lemunion was supposed to be, I think, the last speaker. He had to cancel due to a surgery that he could not postpone, and he wanted me to pass along his regrets for two things. One is that he dearly wanted to be here, and the other is he really sees the need for the states to call an Article 5 convention, and he wanted to put in his 2 cents on that one. So I wish Mr. Lemunion well with the surgery, and he'll be here in spirit. The title of the symposium is Renewing the Compact, How Article 5 Empowers the People of All the States. Let me just read to you a bit of Article 5. Article 5 is the prescribed way to amend the Constitution. And I'm not getting into great detail because I'll probably embarrass myself because these other people know much more about it than I do. Article 5, in part, says, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof. So the amendatory process can start with Congress, or it can come up from the states. And one more time, this is the way that the Constitution says the amendatory process is to proceed. I want to talk a little bit about the theory of the Constitution, the theory of amending it, and why an Article 5 convention is so important. The idea of the Article 5 convention is important. Start with the preamble of the Constitution, we the people. The theory here is very simple, and that is that the power resides in the people, is retained by the people, and should be exercised by the people. And as these gentlemen talk, I'd just like you to think about whether or not an Article 5 convention would allow the power to go back to the people in a way that it doesn't through the normal political process. Now, as a con law teacher, the notion that's dear to my heart, of course, is one of separation of powers. That there are 3 branches of the federal government, each has its prescribed role under the Constitution, and one of those roles is to serve as a check and balance on the others. Now, I don't know what that means, but it's beyond dispute that when you start a constitutional discussion, you start with the Constitution. And people like Justice Scalia will say, and by the way, you end with the Constitution. That's it. You start and end with it. As I said to you before, when I read Article 5, there is one way to amend it. However, one constitutional way to amend it. One of the issues that floats throughout this discussion is whether the courts, the federal judiciary, has usurped the role of the Constitution and basically served to amend it through its decisions. Now, the role of the court after Marbury versus Madison is to interpret the Constitution. And I guess there's a line there, I don't know how fine it is, but there's a line between interpreting the Constitution and amending the Constitution. And to a large extent, that's what this discussion is about. Let me make the point by talking about one case. The case is Morrison versus Olson. It's a 1988 case. Chief Justice Rehnquist wrote for the court. And in that one, the issue, in part, was whether Congress could impose restrictions on the Attorney General's ability to remove a special prosecutor. Can the Attorney General remove a special prosecutor at will? Because special prosecutors in the executive branch, the Attorney General's in the executive branch, and who's the boss? The President. And by the way, Article 2 of the Constitution says, the executive power shall be vested in a president. The executive power shall be vested in a president. Justice Scalia, in his dissent in Morrison, says, and you know what that means? That means all executive power is vested in the president. What happens in Morrison is Congress imposes restrictions on the removal of the special prosecutor. And some of you may remember, some of you weren't even born yet, but some of you may remember this came right out of Richard Nixon and Watergate. When President Nixon wanted to fire Archibald Cox, who was the special prosecutor appointed by Congress in the Watergate investigation. And the thing was that Cox was doing too good a job, getting too close to the White House. So Nixon wanted to fire him. If you look at the organizational chart, that's perfectly okay. The president is the chief executive, head of the executive branch, attorney general works for him, special prosecutor works for him. This is easy. What happened with that was kind of interesting, especially in retrospect. Archibald Cox was special prosecutor. Do you remember? Some of you remember. President Nixon went to his attorney general, Elliot Richardson, and said, fire that guy. Elliot Richardson, the Attorney General of the United States, said, no thank you, Mr. President, I quit. Now think about this. The Attorney General of the United States quits. So Nixon's looking around. He finds William Ruckelshaus, who's an assistant U.S. Attorney General. He says, Bill, fire that guy, will you? So, nope, not going to do it. Not going to do it. So Nixon is 0 for 2. He finally finds Robert Bork running around the White House. Robert Bork was Solicitor General at the time, and he said, Mr. Bork, would you fire him? And he said, oh boy, oh boy, oh boy, let me at him. And Bork fired Archibald Cox. After that, the Ethics in Government Act of 1978 was passed. And part of the act said that the Attorney General could not remove a special prosecutor appointed by Congress. So the question was whether that removal restriction was constitutional. The majority of the United States Supreme Court in Morrison versus Olson said that it was. And the reasoning they used was a little funny, I have to admit, according to my light anyway. What they said was that it was okay because Congress, in imposing the removal restriction, did not take too much power away from the president. They did not sufficiently impair the power of the executive branch. So the rule after Morrison versus Olson was kind of, Congress can take some power away from the president, but don't take too much. Which brings up the question, of course, how much is too much? Now, Justice Scalia, in his dissent, I think this one makes Justice Scalia's greatest hits album. Great writer, absolutely great writer. Justice Scalia says, wait a minute, you guys are going about this all wrong. What I'm talking about is whether the majority amended the Constitution. Justice Scalia says, you know that Article 2 thing there in the Constitution? It says, the executive power shall be vested in a president. That means all executive power is vested in the president. The Constitution says. Justice Scalia then goes on to say, that means if Congress takes away any power from the president, it's unconstitutional. You have to comply with the Constitution. And Scalia said, if you want to change it, which is the subject of our symposium. How do you change it? Through Article 5. And the theory is not through judges changing the language or meaning of the document. Because remember what the majority said in Morrison, don't take too much power away. The president has most executive power except for the teeny-weeny bit that we took away. Scalia says, oh, no, you can't do this. There is a proper way to go about it, and there's an inappropriate way to go about it, and you guys just chose the wrong one. Separation of powers, very important notion, and it runs through all of the discussions today. We've got I think, an absolutely great panel. And by the way, I want to take this opportunity, and I'm going to do it again, by the way, so too bad, to thank Professor Chris Trudeau, who's the advisor to the Law Review, for setting up this entire symposium. I've been on the outside on this one for the most part, and Chris has done an absolutely terrific job. in setting this up and getting the speakers, and I want to thank you. Our first speaker is Professor Rob Nettleson. Professor Nettleson is a senior fellow in constitutional jurisprudence at the Independence Institute in Denver. He's a senior fellow at the Goldwater Institute in Phoenix, and recently retired from the University of Montana, where he was a professor of constitutional law. Professor Nettleson is a perfect first speaker for this, I think, because he's going to set the stage for us. He's recognized as an expert on the framing and adoption of the United States Constitution. He's co-authored The Origins of the Necessary and Proper Clause, published by Cambridge University Press. He's published the Original Constitution, published by the 10th Amendment Center. He edits the webpage, The Scholarship of the Original Understanding of the Constitution. Professor Nettleson also served as a journalist and a radio talk show host, which is interesting. And I think you'll see that reflected when he gets up here, because I've talked to him, and a delightful guy. In June 2000, Professor Nettleson was runner-up among 5 candidates in the party primaries for governor of Montana. So, I don't know if the guy has done it all, but he's certainly done a lot. And it's my pleasure to introduce Professor Rob Nettleson.